have no issue with that. If you want to trail it to later today, I'm okay with that as well.
Okay, let me take a quick read of it. My guess is that it was e-filed Friday, but I prepared over the weekend, and it probably didn't get actually physically filed until this morning, or I would have seen it. Let me check when that actually occurred. Yeah, that's correct. It was actually filed by the clerk this morning. So let me take a quick read of it, see what we got. Did Ms. Lee get a copy of it?
Yes.
Ms. Lee, did you get a copy of that responsive declaration that was e-filed on Friday?
Yes, I got it through email.
Okay, give me just a moment. Yeah, so one of the things that's here, which I had concluded when I was preparing the matter last evening, was that I think I still have jurisdiction to impose sanctions. I just don't think I have jurisdiction to modify the order. I can enforce the order, and I can impose sanctions for failing to follow the order. But in terms of making a change to the order, which is one of the requests that's being made, I just don't have jurisdiction to do that. And I don't have emergency jurisdiction because the child doesn't live in this state, is not currently located in the state. And then there's a point that says that, well, mother acquiesced to the jurisdiction of this state. I don't think that, I mean, you can't, it's a subject matter jurisdiction issue. And I don't think it's waivable. Like both parties can't say, okay, we'd like our case to be heard in California because it's midway between Washington and Arizona. Like they can't stipulate jurisdiction if there doesn't exist any. Let me look at Family Code Section 3428 in terms of being temporary orders. What do you think it means by unjustifiable conduct when that's mentioned in statute and in your brief? It says, except as otherwise provided for if the court of this state has jurisdiction under this part because a party seeking to invoke its jurisdiction has engaged in unjustifiable conduct. I don't really know what that means. Trying to think of a circumstance where that might occur.
Give me one moment, Your Honor. I think the unjustifiable conduct that the court or what the legislature intended by that was like a situation where one party takes a minor to a new jurisdiction to establish UCCGA jurisdiction. I think that's what they consider unjustifiable conduct.
Like if mother absconded with the child and fled to California and said, well, I'm here now with the child, so I want California to make emergency jurisdictional orders, even though she's here, after having absconded with the child, that California can decline to exercise jurisdiction simply because of that. Is that what they're trying to convey?
That's how I read it. That's how I read it. And that's, I believe, how it was intended. And I think there's some case law that indicates that, but if she's fleeing for purpose of domestic violence or to flee a domestic violence situation, that wouldn't be unjustifiable. So that would be an exception.
And then it says, if the court of this state declines to exercise its jurisdiction pursuant to subdivision A, it may fashion an appropriate remedy to ensure the safety of the child. I just don't think there's a safety issue here. Like if there was no other court ready to take this case at this point, I mean, again, even if the child was here, I could make an emergency order to ensure the safety of the child until another court exercises jurisdiction. But we all know where the child is right now. I think the child is wherever mother is where the child is currently. They have the ability to exercise emergency jurisdiction, if nothing else, because the child is there. There's nothing about California that feels right to me about this in terms of issuing an order. We're certainly not the most convenient form. If I were to have a hearing, people would be flying in from all the country to come here. Like me and you, Mr. Mears, are the only ones here. And so we certainly are a forum non-convenience. We, both parties have left the state under the UCCJEA. I can make temporary emergency orders under 3424 if the child is present in the state. And if it was an emergency. And under 3422, it clearly states that I have continuing exclusive jurisdiction until either of the following occurs. And one of those following is that neither the child nor the child and one parent, nor the child and a parent acting as a parent, or a person acting as a parent have a connection to California any longer. Well, I feel pretty convinced that I don't have jurisdiction under the UCCJEA to modify this order any longer. Let me pull something up real fast. Ms. Lee, where do you reside right now?
San Antonio Valley, Arizona,
When did you relocate there?
in 2019.
And Mr. Mears, your client is it Missouri, or I forget where your client is?
Missouri.
And when did he relocate to Missouri?
Mr. Lee?
Okay. Okay. Hmm. Another issue. What I'm mulling over right now, just to think out loud for a moment, is that 3422 says that if a parent and the child, if both parents and the child or children have left the state, that this state no longer has exclusive continuing jurisdiction over the custody issues. But that's different than saying that I no longer have any jurisdiction. It uses the word exclusive. Which suggests to me that maybe I have the jurisdiction since no other state has stepped forward until another state has stepped forward. But I can't find any case law that supports that interpretation. And the only case I could find that talked about it at all was where the mother and the child had moved to Washington. There was no father, and a grandparent sought to finish their petition to adjudicate custody or some parent visitation. And the court held that California lost jurisdiction based on the fact that the mother and the child had moved. The court could not make orders here. And in fact, they reversed the trial court after the trial court did do that. Says it's not the party's departure that if this is a case called AM versus Superior Court, it is not the party's departure itself that terminates the decree state's exclusive continuing jurisdiction under the UCC-JEA. Rather, it's when the court determines that all parties have ceased residing there that jurisdiction is lost. So I think I think I'm just compelled to make a finding that California no longer has jurisdiction to modify these orders. I can enforce them, however. There is a request for order seeking sanctions in the amount of, I think it was $1,000, for having to pursue enforcement of this order. Ms. Lee, do you want to be heard on that? Actually, I think it's for, yeah, it's for $1,000. There was a previous sanction of $1,184. Was that paid?
No, it wasn't.
That was never paid. And my attorney fees and costs to date, excluding today, Your Honor, is $1,784.11.
Ms. Lee, you want to be heard?
At the moment, I'm unemployed. I'm unable to pay that. I don't think it's fair for me to pay that.
At the moment, you said you're unemployed. Is that what you said?
Yes.
Are you receiving unemployment income?
Yes.
How much do you receive?
$300 a week.
$300 a week?
Yes,
How long have you been unemployed?
for about a month now.
Why did you become unemployed?
I was in a seasonal position that ended.
I'm sorry, I'm just not hearing you very well. Can you repeat it a little bit louder?
I was in a seasonal position and it ended.
Are you seeking new employment?
Yes, I am.
In the past, have you been involved in seasonal employment where you became unemployed for periods of time?
Yes.
And typically, how long does it take you to become employed? A couple of months?
About a month or two.
What about from a substantive point of view? Do you have any justification for your behavior here?
It's just a simple fact, me and Mr. Lee just can't talk on civil terms.
Yes, I know that's why I issued an order so that you guys didn't have to talk anymore. You just had to follow the order.
I understand.
And for some reason, I saw your text communications between each other. You actually did speak civilly, I thought.
No, we had no issue with the visitation, but the last time that my son went to Missouri and I was dropping him off at the airport, I was notified that his significant other was emergency to pick up. I simply called Mr. Lee to get her telephone number so I can receive his ticket. And this is where this is started from.
You wanted her phone number for what reason?
So in order for me to get my son's ticket to go to Missouri, you have to give the number of the person, the secondary person that's going to pick up the child. I was not aware that she was put on the list. In the midst of that, I called Mr. Lee at the ticket booth in the airport to let him know that I needed her telephone number to get the ticket. He refused to give it to me. I had to literally give my phone to the ticket agent for him to give the number. And this is where this is all occurring from.
Okay, but did he give it to her?
Yes, he gave it to her.
Okay. So then why didn't this trip occur?
This trip did occur. He went with them last summer. I asked Mr. Lee several times, can we talk
No,
about
this is about the winter time we're talking about
This
now,
wasn't a
right?
winter break. He didn't go to Missouri in winter. Saying this
Right,
all occurred
right,
during
right.
summer break.
That's the whole issue here, right? He wanted to visit during the winter time and you were not allowing it. Is that not, am I misunderstanding?
That's correct.
Okay. And the reason that you didn't allow it was because according to your text messages, you wanted someone else's phone number.
This is way past the phone number, Judge. This is the simple fact that me and Mr. Lee cannot talk civil. The simple
No,
fact
but
that
I'm looking in your communications with him and you're asking him for someone else's phone number and he's saying, I don't need your phone number.
All the text messages, not just the text messages that Mr. Lee sent. I sit there and I said that I have no issue with him or his significant other. It's just a simple fact that we need to come together because we are all raising the same child to come to an understanding. My child is left alone with this other person, and I just literally want a number just in case for emergency. That's
right.
it.
And so the reason you didn't allow the child to travel because you thought you had a right to know his girlfriend's phone number in case there was emergency.
This is way past the number, Judge.
It's not, because I'm looking at your communications from November, and in your communications from November, you're telling him that you need a phone number.
Mr. Lee,
I'm looking at your text from November 7th, I think it was. Let me pull it back up. He wrote, I'm trying to get this plane ticket sooner rather than later. Prices will keep climbing. And you wrote back and said, FYI, I already told you how I feel about Aries going back to St. Louis at the moment. And he wrote back to you and said, there's nothing in the paperwork that says anyone has to give you their phone number other than me. The fact that you're willing to keep our child from seeing me is because you don't have my girl's phone number is insane and says a lot. You'd be breaking the order 100%, but I'm not. And then he still says he's willing to do that if that's what it takes to get the child. And then you wrote something. He says, I'm waiting. And he wrote you back. And you said, refer to my November 7th text. I've already answered you. And going back, it looks like that text is the one where you said, as best I can tell, that you have concerns about him traveling to St. Louis. So you just decided on your own, you just didn't want the child to go to St. Louis. And you had your reasons, but they apparently, according to you now, it has nothing to do with the phone number. Now it had to do with the fact that, well, I don't know what the reason is now. What is exactly the reason that you didn't want the child to go? What was it worth violating the court order over?
Simple fact, Judge, that my child is left alone with the whole person that he has gone to St. Louis many a times. I simply asked Mr. Lee, you feel me, if we could come to an understanding, you feel me, the simple fact that if we exchange numbers, just in case there's an emergency, don't need to talk to a significant other. This is very frustrating, simple fact that this is literally like the center point of my issue. Has nothing to do with her telephone number. It's a simple fact that my child comes back from Missouri during the summer break and tells me that, oh, I'm left alone with Shyla. I'm going here with Shyla. That's totally fine. We have made this a point in court plenty of times. The simple fact, I'm literally trying to co-parent with Mr. Lee, and every time that he doesn't go his way, we're back in court.
And by his way, you mean that the child actually gets to see him?
He has saw him. Since the last time we have been to the court, the child has been to Missouri multiple times.
Yeah. But he didn't get his winter visitation because you didn't want him to have it. You just thought that you just didn't want him to have it. So you said, no, I'm not going to let you have it. I have the football in my possession, and I'm not going to hand it off.
You're putting words in my mouth now.
You wrote to him, as a mother, I want to know who is around my child. And as your partner is soon to become a new mother, she'll also develop a concern. You're talking about his girlfriend there. You just think you have that right, and you don't. And then you even told him you can go ahead and buy the ticket if you want to, but you better get travel insurance so you can get a refund. You know, unless we agree, I have the football and I'm not letting you have her. That's just not the way it works. If I could make an order today, my inclination would be to switch custody and let him have the child. And that way you can beg for your winter visitation and see how it feels to be on the short end of that stick. Okay, so the court's going to find that it does not have jurisdiction to issue any custody orders under the UCCJEA any longer, that jurisdiction rests either with Missouri or with Arizona, but no longer with California. I am going to issue an order that Ms. Lee is to pay Mr. Lee. Do you want directly to your attorney, to the attorney's office, or do you want directly to Mr. Lee? Mr. Ramirez.
Mr. Lee, what's your preference? You want her to pay me directly and then I pay it to you, or do you want her to pay you directly?
Okay, $1,784 pursuant to Family Code Section 271. Set amount to be paid no later than. My mother's currently unemployed. I want to make sure she has a resource to pay it. She said she'll be reemployed typically within a month or two. It's a seasonal issue. She's still receiving employment at this time, but I am going to give her some time to pay it, even though she hasn't paid the prior amount, which, by the way, is accruing interest at a rate of 10%. So will this, if it's not paid when it's due. I'll have it be made due by June 1st. It'll accrue 10% interest thereafter if paid in full. And at this point, it seems that if Mr. Lee wants relief, he's going to have to find that relief either in Arizona or in Missouri. My guess is, since the child is in Arizona at this time, and has been residing there, that he at least would need to go there and ask them to issue orders. And if change the child's custody to Missouri, then decide how to handle that on a matter of, but at least I feel like they should exercise temporary jurisdiction, if nothing else. But I'll leave that up to them. I'm just not going to exercise jurisdiction here any longer, beyond the orders that I just made. Okay, so those will be the orders, and we'll provide a copy of the minute order to you, Mr. Ramirez, in your box. I'll ask that you email a copy to Ms. Lee. You have her email address?
Yes,
Okay. All right, to all of you.
thank you, Your Honor.
Yes. Oh, no, there are orders, they're valid and they're enforceable. You could register these orders in Missouri, I mean, in Arizona, and have law enforcement enforce them. If she doesn't follow the orders there, it's just, it's punishable as a criminal offense. She could go to jail for not complying with a custody order, even though it's a California custody order. But but that your ability to enforce it is really going to be in Arizona at this point. And if you want to modify the order, you need to get in front of an Arizona judge. They don't pay, there's no home field advantage. And if you're in front of an Arizona judge and he or she sees the matter the way I do, they'll make the order. There's nothing unique about my situation here. They will consider the facts. They'll consider mother's arguments and yours, and then they'll make a new custody order for you. And and if she's not complying with the existing orders, an Arizona law enforcement officer can put handcuffs on her and take her away until she does. It happens when people don't comply with their custody orders. That's one of the relief that one of the avenues of relief that is available, which is that people go to jail for it. It's a crime. In fact, it says it on your order. If I'm not mistaken, I'd have to look at your specific order, but typically it's literally written into the order. That failure to comply with the order is a crime. Let me look at your existing order, which was from, looks like July. Yeah, this is a violation of this order may subject the party to be in violation of civil or criminal penalties or both. So it's just the way it is. But I can't insist any longer in this matter. If I could, I would. Mother would be entitled to due process. To have to have a different kind of hearing than we had today. If I was going to make a change in custody of that nature, but I can't make any changes. But you have a history now, 2 instances in which mother was sanctioned for failing to comply with the order, and I think any judge would be sympathetic to that and try to make sure their orders are crafted in a way that has ramifications if that happens again. I just genuinely think, Ms. Lee, you have a misunderstanding of what your role is here. And if you feel that the child shouldn't go because you want to know what the name of the babysitter is at dad's house, and if you think you have that entitlement, then you could file a request for order here and get an order within 24 hours that says, Your Honor, I don't want to send the child to Missouri because I don't know who the babysitter is between 8 o'clock and 9 p.m. on Thursday evenings, and I'd like to know who it is. I don't want to send the child there for all of winter break until I know. And then I'll consider your request and I get to make a decision on that, and then I'll decide. But you don't get to just say, you know what, you didn't do things my way. I have the child in my possession. I'm going to take her and go home, and good luck, and I'll see you in court. And then expect nothing to happen when you see him in court. And that's what's happened so far. And I honestly have no problem changing custody. It's actually really easy because all I have to do is go through the order and change mother to father every time, and change father to mother every time. And then I sign the paperwork, and then you're on, and he comes by and picks up the child, and then you're on your own. I can literally do it in 5 minutes. I've done it. I've done it many times. If a parent doesn't follow the order and deprives the other parent of their visitation and shows me that they don't understand what the importance of the other parent's visitation, I will change the custody order, and then I'll let the other person try to show me that they know better. No problem. And it's unfortunate because we have a child who I previously made a determination would be better served in your primary care. That's why the order is there right now. On the other hand, that assumed that you were going to comply with the orders. And if you don't, then it would be in the child's best interest to be in his care. And the child's 7 years old, just turned 8. I don't like to make orders that change an 8-year-old's life, the stroke of a pen. But when she's 25, she'll barely remember it. And I have no problem with her growing up in Missouri. I went to school there, lived there for 4 years. It's a wonderful state. I'm sure Arizona's a wonderful state. But if you don't learn to follow these orders, she's going to grow up with dad. And then you're going to be left saying, well, that judge, he was so unfair. And you can say whatever you want. But the fact of the matter is, you don't have a right to deprive him of his visitation for any reason without another court order. And I can get your court order in 24 hours. But you didn't ask for one. You just self-medicated and decided, I've got her in my control right now, and you lose because I have her in my possession, like a football. She's not a football. She's a child. And you punished her and didn't let her see her dad. Why? Because he wouldn't tell you his girlfriend's whereabouts or her number or whatever the issue was.
It has nothing to do with the simple fact that it's playing football. It has nothing to do with that, sir. The simple fact that you're getting a little inch of what stuff that I go through with this man.
I don't care what you go through.
I know you don't care,
really don't.
sir.
I just don't care. It's unfortunate that you're going through anything at all. But we already been down this road, and I made an order. And you know what? You failed, and you got custody of the child, and you got to go to Arizona with the child, and she's been in your care. Okay? But you don't get to abuse that. And he shouldn't have to beg for his visits. And he doesn't work for you.
He doesn't beg. He doesn't call.
He doesn't have to answer to every one of your whims.
There's a simple fact that he can't communicate as a civil adult.
He doesn't even have to do that. He doesn't have to communicate as a civil adult.
That's just crazy to me. How you can sit here, you feel me, don't know anything about what's going on with this child and come up in here and literally think that you can snatch him.
The only thing I need to know at this point is that you're following the order.
Okay, thank you, sir.
And everything else is secondary to that at this point, because you have no basis to not follow the order. And you could sit there and say, well, I do, because he doesn't talk respectfully to us. We don't communicate. He's a really mean guy. And you know what? All those things could be true. Everything you're saying could be true. You still can't take the child from him and deprive him of his visitation. Even if you don't like him, even if it's a bad guy, even if he lies to you, even if he's having an affair behind his girlfriend's back, none of that matters. There's an order that's already in place. He has a right to his visitation, period. End of sentence. Now, if you want to change that, you can file a request to modify the visitation orders. That's up to you to do. You didn't do that. You decided you're in charge. I don't need the judge's order. I know there's already an order that says dad has a child for this period of time, but I have the child. Neener, the judge doesn't. So I'm not going to give him the child, even though the judge ordered me to do so, because the child's in my possession. And until I let go, she doesn't go anywhere. I don't care what the order says. And what I'm telling you is, you could say that all you want until there's an order that says dad gets to try now, and then you're going to care, and we're not going to listen to you anymore. And some judge somewhere is going to hold you accountable for this, because you're both not here. I can't do it. But I'm telling you right now, a judge is going to. And then you'll come back and you'll say, wow, that commissioner, he was really clairvoyant. He was right after all. I should have listened. And what you keep wanting to do is come up with excuses. And what I'm telling you is there are none.
It's not excuses, sir.
You want a new court order? That you could get. Absent that, you don't get to do this on your own. What if he had the child for his summer visit and said, well, you know what? She told me that mom keeps the house messy, so I'm going to let her stay here and I'm not going to send her back. And I'm going to enroll her in school. What would you do? What if he says, well, mom doesn't communicate with me. She doesn't call me back. She's really mean. She's got a boyfriend. I don't even know what his number is. She won't even tell me his name for that matter. There's someone else living in the house that she won't tell me who it is. So I'm just going to keep her here. Pretty sure you wouldn't allow that to happen. All right. I've made my orders. We'll get them in order to you, Mr. Ramirez. The request for order filed by father to modify the visitation order is denied because of a lack of subject matter jurisdiction. The sanctioned order is issued, and mother's request request to move jurisdiction to Arizona is denied. But this court will make an order that I'm relinquishing jurisdiction. And when Arizona issues an order, they can have jurisdiction. Or if Missouri issues an order, they can have jurisdiction. I can't give them jurisdiction they could take it. I'm offering it to them. It's up for them to have it. And I'll relinquish jurisdiction to any court that assumes jurisdiction of the UCCJEA and issues a custody order in that state. So that'll be the order. I gotta switch this over to you now. I was gonna send it to her.
Thank you, Your Honor.
All right, good luck to all of you. All right, I'm leaving Zoom.